We expanded the concept a little to allow for a longer runtime, if you wish. The brainchild of this is Brian Schweitzer or those under his control. That's who coined the phrase. The attempt to blame a radio station for having him violate the law simply doesn't wash here. And I think that I understand the governor's trying to avoid the consequence of his actions. I understand that he's trying to say that this plain language is ambiguous to try to create some doubt. But I don't abide by trying to whitewash what happened here and say that I was asked to do this and that's all that was done. Because the governor himself has so screwed up the facts on this simple little story that he had to tell. For example, the first affidavit in the record is from Miss Elliott. And she says, I received a request for this in early March. That implies, though, that she received the request from Miss Lark prior to March 5, when they actually made the radio announcements. Later, inappropriately, and to supplement the already inconsistent factual record, inconsistent because that implication was rebutted by Miss Lark's email sent after it was sent on March 6th. The request, there is a written request from a radio station, but it came the day after the governor actually made these ads. You can't square that, we can't ignore it. Then Mr. Zeller, trying to fix things, I guess, was asked to put in an affidavit. And he says, well, the request was actually received in late February. Well, that didn't change Ms. Lark's March 6 email. On this record, there's no inherent reliability as to what did or didn't happen. And, Your Honor, I was a newspaper man before I went to law school and met you. And this seems like pure, unadulterated malarkey to me. This is a very simple story to tell. A red flag goes up just by my nature. Why can't they tell it correctly? Why couldn't they make a simple record on it? Why wouldn't they let me conduct discovery to make a simple record so we would know exactly what happened? And, that requires some digging, I think. We only have to go to these facts, which I vehemently dispute, and I don't believe, and I won't believe until I have an opportunity to cross-examine and present other witnesses, present people who may have talked to these folks, talked to campaign people. Wouldn't it be something if we find out that a campaign advisor sat with them? Wouldn't it be something if this text was reviewed by the campaign as part of the seamless branding effort? That's certainly, in the mind of the average taxpayer, detracts from this appearance of legitimacy or the appearance of you're really going to hamper a legitimate function of my office. Your Honor, I understand that I'm going to have a little bit of a rebuttal time, and if you have any questions, that's fine. The last comment I'd like to make, which struck me as a taxpayer, or from the taxpayer perspective, as way off the mark, is the notion that state workers are going to be paid whether or not they do illegal conduct or not. So, on that rationale, the governor could send Ms. Elliott out to paint campaign signs statewide, and it would not be a violation of the law. That misses the point here. Any candidate, Republican or Democrat, is bound by this simple law. And the law is violated when state funds are used for any purpose in connection with such an ad or this public service announcement, such as found here. So for these reasons, Your Honor, I have restated the proposed facts that you had sent to us. I'm going to give my friend a copy of it before I approach the bench so he doesn't have to question.
statement that you previously sent me?
No, it is not.
Okay.
And, Your Honor,
Okay.
where it differs is it excludes the argumentative policy debates.
Okay.
It lays out what the Republicans believe are the clear facts here. These are the facts that I discussed in our conference call, where we discussed the possibility for efficiency's sake of trying to put a legal issue before you in a proper context. In your opening statement today, you indicated that the Republicans felt that there was material fact disputes that preclude summary judgment. I don't think so, if you're willing to find facts like these. In fact, I think you can enter summary judgment against the governor with no further evidentiary hearing just on these facts. This is the prima facie case that I presented before you. And the laws set forth as you've set it forth, and the question is simply restated. When the governor admits that he used or permitted the use of state funds for this PSA, did he violate the statute that says you may not use funds for PSAs? And the answer is clear, yes. That's the difference. Where I can't, the only hang up here on the facts, Your Honor, is if you are truly concerned about the impact beyond the facts before you, if you're going to worry about the Surgeon General, you know, and I think right now a more legitimate public needs would be, for example, the brucellosis issue, for example, the fires that are occurring. You can think of a real meaty situation where you would think, yeah, we'd like to hear from the governor on this. Well, there isn't a single thing in the statute that prevents him from walking out under Thomas Francis Meagher and conducting an interview. There isn't a single thing in the statute that prevents him from writing an op-ed piece. There's not a single thing in the statute that would have prevented him from doing what he did if he would only used his own telephone, or if he would have said to Miss Lark, sure, I can do that, come on over here, I'll record the statement, because I can't use state funds to pay for my people to do it. You come over here, meets her at Wendy's, whatever, makes his statement, that is legal. He just can't use state funds to do it. Now, let's say that something develops in the brucellosis matter or in the fire matter, and my hypothetical with fires is a bit fragile because he could declare a state of emergency, and there could be announcements directly from the governor on point that could lawfully be done here. But let's assume that it's not quite rising to the level of an emergency. What the governor hasn't answered is what the legislature did. The legislators debated extensively after Betsy Brown came down on behalf of the administration and asked them to give this governor some leeway. Let us put out PSAs for travel. That's really important. He said, no, there are all kinds of important things. We don't want you to do that. This is important. It's going to apply across the board. People are tired of it. They pointed out that other people in the administration can serve important communication purposes, Your Honor, by simply, what would be wrong with Sarah Elliott coming out and making her comment about brucellosis? Or what's wrong with some other non-candidate connected to the administration from making a public service announcement with the Surgeon General? Nothing. But more importantly, there's no fact in the record here that you can rely on to reach a determination, in my humble opinion, that a negative determination against the governor here would interrupt any function of his role or the government.